Rick Newman here with another in our video interview series. If you have been concerned with the increasing onslaught on women's rights and reproductive rights, then you should watch this video. Our guest today is Mary Ziegler, the Stearns Weaver Miller Professor at Florida State University College of Law and a nationally known expert in the legal history of reproduction, the family, sexuality, and the Constitution. Most recently, Professor Ziegler wrote an article for the New York Times published on March 3rd, last week, titled, "South Carolina Shows Where the Anti-Abortion Movement is Headed. Taking their cue from Trump, absolutists are going all out to overturn Roe versus Wade." Welcome, Professor Ziegler. It's a pleasure meeting you and having you here.
Well, thanks for having me.
Let's start with two central landmarks in the question of reproductive rights, and those are the 1973 Supreme Court case of Roe versus Wade and the 1992 decision, also by the Supreme Court, Planned Parenthood versus Casey.
Right.
What are those cases and why are they so important?
Well, most everyone, I think, has heard of Roe v. Wade. Roe came on the heels of a line of decisions involving the scope of the right to privacy, in particular, whether the right to privacy had anything to do with decisions involving reproduction. So in recent years, the court had held that the right to privacy was broad enough to encompass married couples' decision to use birth control and even single people's decision as well. And so Roe asked whether that right also covered the decision to end a pregnancy as well as to prevent one. So the court was dealing with two laws, a Texas law that banned almost all abortions unless there was a threat to a patient's life, and a second one that was a little bit more forgiving, but had been kind of from an era where the states were reforming but not repealing restrictions on abortion. And the court ended up invalidating both of those laws and along the way striking down the laws that were in almost all states at the time, holding that there was a right to privacy that covered a patient's decision to end a pregnancy with the consultation of a doctor. At the time, the court laid out what it called the trimester framework. So basically, abortion would be broadly legal and difficult for states to permissibly regulate in the first trimester of pregnancy, could be regulated only to protect patient health in the second trimester, and only at fetal viability, so the point at which life outside the womb was possible or survival was possible, would states be able to advance an interest in fetal life. The court also significantly rejected some of the arguments we're starting to see come back in recent days, rejected the idea that personhood began at fertilization. The court treated personhood not as a question of biology necessarily, but more as a question of just the text of the Constitution. And the justices noticed that the word person usually applied to people or actors only after birth. The court also held there was no compelling interest in protecting life, largely reasoning that because people disagreed about when meaningful life began, states couldn't pick and choose definitions and impose them on everyone else. Casey is a much less well-known decision, but in some ways it's as significant, especially for us today, because Casey is the actual law on abortion as we speak. In the 90s, just like now, there was a conservative supermajority on the Supreme Court that was widely expected to reverse Roe, but that majority defied expectations and preserved what it called the essential holding of Roe, namely that there is a right to abortion. But Casey also got rid of the trimester framework and replaced it with something that looked much more deferential to states looking to regulate abortion. So the so-called undue burden test that the states introduced, that the court introduced, would make regulations unconstitutional only if they had the purpose or effect of creating a substantial obstacle for people seeking abortion. And it wasn't clear what that meant exactly, but the court upheld all but one of the restrictions before it at the time. So it made it seem under Casey that abortion restrictions would be easy to pass, but that abortion rights were still protected. Casey was also significant because the court, for the first time, recognized that there was a connection not only between privacy or autonomy and abortion, but also between equality, particularly for women and other pregnant people, and abortion. So really now when we're talking about whether abortion in America will be protected or legal anymore, we're talking about whether the court is going to overturn not just Roe, but Casey as well.
Yeah, it seems like there is a sort of an inherent tension in the Casey decision between, on the one hand, affirming that there is a right to abortion, and on the other hand, saying, meanwhile, states can regulate abortion so long as it's not unduly burdensome, without
Mhm.
really defining what unduly burdensome means.
Yeah, well, ever since we've really been fighting about that, right? So there was a time when abortion opponents basically argued that undue burden meant that states couldn't criminalize all abortions and that any regulations that stopped short of that were fine. That seems to not be true, but it's not settled yet. So, right, the Supreme Court has struck down a law requiring married women to get their husband's consent for abortion or actually to notify them that they're having abortions. The court in recent years has struck down laws requiring states to, or requiring abortion clinics to either have admitting privileges at nearby hospitals or comply with the regulations that govern other ambulatory surgical centers. So clearly, it's not just abortion bans that count as undue burdens, but exactly what an undue burden means remains unclear. So, one way that you could imagine the erosion of abortion rights occurring would be for the court to define an undue burden more and more narrowly to give states more and more leeway to regulate abortion. And I think that would probably be the preferred path of Chief Justice John Roberts, who just recently wrote an opinion doing just that. So there was a case this summer called June Medical Services versus Russo that involved a Louisiana law about admitting privileges. The tricky thing, though, is that the court had struck down an identical Texas law just 4 years earlier. And Roberts joined his liberal colleagues in holding the law was unconstitutional, but he wrote a separate opinion. He didn't agree with the reasons they reached their conclusion. And in his opinion, he said essentially he thinks an undue burden is much harder to prove than the liberal justices seem to think. And in particular, he reasoned that it wouldn't matter if a law on abortion basically had added no value or served no purpose. All that mattered was whether it limited access past a certain point. So Roberts seems to be headed in the direction of allowing for more and more abortion restrictions, even if he still at least has some interest in respect for precedent, which was the reason he gave for invalidating this Louisiana law.
Yeah, and so this is a sort of a backdoor attack on the right or access to abortions. Instead of a frontal assault saying repeal Roe versus Wade, it's more like the death of a thousand cuts, with legislation adding more and more and more restrictions, making it tougher and tougher for women to get abortions. Am I
Right. I mean, I think at the moment we're seeing both, right? So we see in the states and in the courts as they consider laws passed by the states, we're seeing some death of a thousand cuts kinds of laws. So, for example, laws banning abortions for specific reasons, like in cases of Down syndrome or sex selection, laws either banning telemedicine abortion or restricting it, laws banning the most common surgical procedures governing abortion. We're also seeing frontal assaults as well. Probably the most familiar are so-called heartbeat bills. There have been roughly a dozen states that have passed these bills in recent weeks and years, actually. These laws ban abortion sometime somewhere between the 6th and 8th week of pregnancy when fetal cardiac activity can be detected. There are also laws like a recent statute passed in Arkansas or one some time ago in Alabama that criminalize virtually all abortions from fertilization onward with no exceptions for rape and incest. So I think if you're looking at anti-abortion strategy, you divide it into those two camps, right? People who are taking a more incremental approach and people who are looking to kind of go immediately to the decimation of Roe without any kind of pause.
All right, let's talk about both different approaches. The first one is so-called death of a thousand cuts, bans on abortion for Down syndrome. I think that an appellate court in Tennessee upheld that, or am I misunderstanding?
Yeah, there have been the fate of these laws is sort of up in the air. So for example, the Seventh Circuit Court of Appeals, which is significant because Amy Coney Barrett was a judge on that court before she became a Supreme Court justice, had struck down that kind of law with Barrett dissenting. But the Supreme Court then sent it back for another look, suggesting that maybe the outcome would be different with Justice Roberts' new idea of an undue burden. And states, I think lots of states are passing these laws, and courts are likely to reach different outcomes. And we're seeing lots of death of a thousand cuts being revisited in the states. Arkansas, which has lots of other abortion restrictions in addition to its recent ban, has several that are now back in front of a lower court, again, applying Roberts' more deferential standard. Texas has the law banning, or not banning, but heavily restricting dilation and evacuation, which is the most common second trimester procedure. So there's really lots of these kind of death of a thousand cuts laws that the Supreme Court will be able to take a look at. And probably the most obvious is that the court has had an abortion case it's been sitting on now since October, one involving a Mississippi law banning abortion at 15 weeks, that the court could choose to hear at any time, like by the end of this month. So that strategy, and I think in some ways that had been the leading strategy for some time, and probably I would imagine savvier players would think the more likely to work strategy, simply because it's a less heavy lift to ask the Supreme Court's conservative majority to kind of make a case to overturn Roe over a period of time, rather than simply changing one or two people on the court and expecting immediate results, which could potentially damage the court's reputation or institutional legitimacy.
But all of these statutes, all the state laws, they must be aimed ultimately at the Supreme Court. I mean, the Arkansas law appears on its face to fly right in the face of Roe versus Wade.
It's all of them. I mean, even incremental laws are all designed to end up at the Supreme Court. So, I mean, a few things to note on that, right? One, all of these are part of an effort that's been unfolding over decades that I document in my book to see to it that Roe is overturned. A second point is that the people who are focusing on incremental thousand cuts laws don't want to stop there. So the end point is still more or less a complete or near complete ban on abortion. And the reason for that isn't hard to understand. People who are opposed to abortion believe life begins at fertilization and that abortion is, for all intents and purposes, murder. So it would be an intolerable result to say that, murder is legal in New York and California, but it's not legal in Arkansas and Alabama. That doesn't make any sense. So the end game would still ideally, from the standpoint of folks in the anti-abortion movement, be a national ban on abortion. We're not likely to get that out of the U.S. Supreme Court, but that, I think, in an ideal world would be where the anti-abortion movement would like to go.
And what do you think we are likely to get out of the Supreme Court?
Well, it's still very up in the air, right? So we know we have a 6-justice conservative majority, but we also know that within that majority, there are different conservative factions. So, for example, Justices Clarence Thomas and Samuel Alito have been pretty open about their desire to overturn Roe as quickly as possible. We also know that Chief Justice Roberts has shown a real reluctance to move quickly when it comes to unraveling Roe, even if he's no friend of abortion rights. And we quite simply don't really know what Justices Neil Gorsuch, Amy Coney Barrett, and Brett Kavanaugh will do, all of former President Trump's nominees. So some of them may prefer Roberts' kind of go slow approach, some of them may not, but we don't know yet. I think we can be pretty confident that abortion rights are going to be rolled back by the Supreme Court, but how quickly and how, I think, really remains an open question. And it's not clear if this is relevant, but in several decisions involving COVID-19 and church openings, Kavanaugh and Barrett have at times joined Chief Justice Roberts. So it's not entirely clear that they're going to be willing to go for something like Arkansas's absolute ban in the next year.
Well, and I want to come back with me now, if you would, to 1992. What underlay the conservative supermajority not using Casey to just overturn Roe and say that's it, no more abortions? What drove that?
Yeah, it's hard to say. I mean, so there was a sort of a group of conservative nominees who ultimately decided that outcome. So Sandra Day O'Connor, David Souter, and Anthony Kennedy. So I think one obvious difference, of course, is that Souter was famously taciturn. He was not that reliably a conservative. The same was true of O'Connor. And of course, Kennedy would become famous for being a swing justice in the years to follow, whether that was about same-sex marriage or a variety of other things. So in part, what drove the decision was that what it meant to be a conservative on the Supreme Court in 1992 is not what it means in 2021. I think there's also always been a difference if the Supreme Court actually could overturn Roe, for a justice to be the one who actually pulls the trigger than it is to be someone writing a dissent, right? So O'Connor, for example, had been very critical of the Roe decision and the idea of fetal viability in particular. But when the time came for her to be the one to see to it that Roe was gone, I think she balked. So it's possible that some of the Supreme Court's current members will react the same way. But I think the counter argument is that in the years since, conservatives have gotten, I think, even better at vetting justices or nominees to the court to ensure that they have the kind of views on Roe that GOP leaders prefer.
And to what extent, if you can answer this, and I'm not sure, I know that Roe versus Wade and Griswold versus Connecticut before that were criticized because they kind of found this right to privacy in the penumbra of rights in the Constitution. It's not specifically laid out. So is the attack on Roe, is it fundamentally just a moral thing that people think, well, abortion is murder, therefore it's wrong? Is it an attack on women that they're getting too uppity and should be put in their place? Is it an attack on the constitutional validity of the notion of privacy? Or is it some blend of all of these? What do you think?
It's complicated, right? I mean, so some people are opposed to abortion. It's clearly about religious faith. So particularly at present, the anti-abortion movement has a strong evangelical Protestant contingent. There are, of course, Catholics, as well as left-leaning Catholics, I would say, who are opposed to abortion for reasons of faith. I think there are some people for whom it's a moral issue, right? There are some people for whom it is about the roles of women. I think that would certainly be true of some traditional evangelical Protestants. There are, I think Roe itself is a fairly weak decision. So there are some people who simply don't like the idea of the logic of the Roe decision. There are people who don't like Roe because they're conservative and don't like the idea of a liberal judiciary, period, and they associate Roe with that kind of broader concept of a liberal judiciary. And so I think it's hard to kind of boil it down to one or two variables. And like most social movements, the anti-abortion movement is a big, complicated movement, and people within it disagree with one another about lots of stuff. And you can get a little bit of a flavor of this from the fallout of the insurrection and response to what people in the anti-abortion movement think of Trump, right? If they think former President Trump is still sort of a savior figure, or if they're trying to distance themselves from him, if they think being opposed to abortion should extend, for example, to things like, the death penalty, or should it extend to things like opposition to contraception on the other end of the aisle. There's a lot of different answers to that question, depending on who you ask, who's opposed to abortion. So it's hard to pinpoint a single reason, because people often have different reasons.
What about the abortions occurred before Roe versus Wade? Abortions occur whether they are legal or illegal. And therefore, it seems to me that one way to look at this issue might be from a who makes the decision standpoint. Do we want to let the decision to have an abortion rest with the pregnant woman? Or do we want it to be a group of legislators in some state capital somewhere? Or am I completely missing a fundamental point here?
No, I mean, I think that's definitely one way of framing it. There's also a sort of legality versus illegality question, because it's almost certainly going to be the case that even if Roe is overturned, people will continue to have abortions. They just won't be legal abortions. Whether they'll be safe is harder to say, because, of course, in a pre-Roe world, that was often not true. but we now have medication abortion that's widely available. So if you want a sort of potential preview of what this may look like, Poland has criminalized almost all abortions, and people in Poland are traveling outside of the country and or getting medication abortion shipped in. So it will be a lot harder for state lawmakers to be the ones who decide, even if in fact the Supreme Court opens the door to outright criminal bans on abortion in a post-Roe world.
And I guess finally, I'm wondering, what do you think the long-term landscape will look like? Even if the courts were to uphold various state efforts to limit access to abortion, so long as Roe versus Wade remains good law, various states could protect the right to abortion.
Sure. I mean, states are in a position to protect abortion even if Roe v. Wade isn't good law. So the only point at which that would change would be if the Supreme Court, for example, recognizes fetal personhood or recognizes a right to life. And at that point, that would mean that abortion probably could not be legal anywhere. Overturning Roe would just have the effect of saying the Constitution says nothing at all about abortion, which means the states can do whatever they want. That means they certainly could criminalize abortion, as Arkansas has recently, but it also means they could equally, protect abortion more than they already do, as some left-leaning states have chosen to do. So we're likely to see a patchwork in the future, just as we have now, but the differences from state to state will be much sharper because we'd expect to see pro-choice states moving further in that direction, and we would expect in a post-Roe world to see much more in the way of outright criminal bans in states that are opposed to abortion, rather than some of the more sort of incremental policies we've become familiar with.
And is there a time frame, or are there going to be a series of cases working their way up to the Supreme Court, or is there one?
Yeah, we don't know. There is no time frame. So one of the sort of silly things you'll see Arkansas lawmakers saying, we're going to force action by the Supreme Court. And no one can force the Supreme Court to do anything, much less on a particular timeline. So we don't even know when the Supreme Court is going to weigh in about whether to take this Mississippi case, much less what will happen in a broader sense. You can be clear about how long a particular law will take to get to the US Supreme Court, but in terms of the big picture about what happens to legal abortion in the US, we really just have to stay tuned.
And why this onslaught now? We have a new administration in Washington, and yet it was only yesterday, I guess, or the day before, that Arkansas passed this new law. What's prompting all of this right now?
Well, all of it is a response to Amy Coney Barrett, really, because I think that after Brett Kavanaugh joined the court, there was a sort of flurry of legislation of this kind. And then things slowed down over the summer because Chief Justice Roberts seemed reluctant to go that quickly. When Amy Coney Barrett was confirmed following the death of Ruth Bader Ginsburg, I think most conservative lawmakers saw that as a sign that there was a sort of insurance policy, and that even if, for example, Chief Justice Roberts did not want to overturn Roe, they believed there would be 5 justices who would be on their side. So you're seeing a flurry of activity in response to what I think abortion opponents hope is a new opportunity at the U.S. Supreme Court.
All right. Well, we will have to watch and see how all of this plays out over the coming, what will be years, I think. This isn't going to be resolved next week or next month. This could be years long. So, well, we'll stay tuned. And if you don't mind, I'd like to check back with you in a year or two and see what the lay of the land is at that time.
Absolutely.
Great. Thank you very much. This is Professor Mary Ziegler from Florida State University College of Law. Thank you again for talking with us today.
My pleasure.